La Cour.
Please be seated. Good afternoon, everybody. The bench welcomes both parties to the dispute. Firstly, I would like to introduce myself. I'm Gilberto Felici, judge of the European Court of Human Rights, and your president of the bench today. Sitting with me are judges Darian Pavli, Gana Judiska, and Susanna Kovalova on my right, and on the left, Erik Wennerström, Armen Arutnyan, and Susanna Zoe Brianston-Cross. First of all, I will start with the members of the applicant team. Do you, arguing on behalf of the party, solemnly promise that you will abide by the rules of the Helga Pedersen Moot court competition and the rules for the oral pleading, and that you will not communicate with or accept assistance from in any way your coaches or other individuals during the oral pleading? Please answer.
We do, Your Honor.
Okay, now I'm addressing the respondent state. Do you, the member of the team, arguing on behalf of the party, solemnly promise that you will abide by the rules of the Helga Pedersen Moot court competition and the rules for the oral pleading, and that you will not communicate with or accept assistance from in any way your coaches or other individuals during the oral pleadings?
We do, Your Honor.
Failure to comply with the rules or to accept help from outside sources, including coaches, can result in the bench recommending your disqualification to ELSA International. The bench now wishes to hear who is appearing for the applicant in this matter. Please.
May it please the court, my name is Matilde Romagnoli, and I'm deeply honored to appear in front of your honors today. We will represent the applicant, Mrs. Murray, and together with my co-counsel, Claudia Espinosa, we intend to take 35 minutes to make our submissions. Together with us, there are the colleagues Adela Casado and Gabriela Georgieva, who will not be pleading today. We intend to take approximately 20 minutes to make our preliminary submissions under admissibility, to then move and analyze the merits of the case under Article 8 of the Convention. My co-counsel will then proceed to take the remaining 15 minutes to analyze the merits of the case under Article 1, Protocol 1 of the Convention. She will also be in charge of rebuttal today. Thank you.
Thank you so much, Counsel. And now I address the same wish to know the appearances of the respondent state team, please.
Thank you. Dear Mr. President, honorable members of the court, dear colleagues, my name is Matěj Pleva, and together with my co-counsels, Jakub Kozumplík, Dan Sklenář, and Alice Sklenářová, we have the honor of representing the respondent, the state of Zemland. The structure of our oral pleading today will be as follows. First, my co-counsel, Dan Sklenář, will argue that the application under Article 8 of the Convention is inadmissible pursuant to Articles 34 and 35 of the Convention. Then my co-counsel, Jakub Kozumplík, will continue with our argumentation to the merits, and namely will address the alleged violation of Article 8 of the Convention. And at last, I will address the alleged violation of Article 1 of Protocol number 1 to the Convention. As far as our division of time, my first co-counsel, Dan Sklenář, will take approximately 7 minutes. My second co-counsel, Jakub Kozumplík, will take 12 minutes, and I will take 16 minutes. As far as our rebuttal is concerned, I will be responsible for it. Alice Sklenářová will not be appearing in this oral pleading and will only be assisting us. Thank you, Your Honor.
Thank you. Now I just ask the timekeepers if everything is fine. Yes? Okay, very well. So the floor is to the applicant, please.
Is dignity, pain, and whether the law should ever be so blind in front of human suffering. The European Convention on Human Rights is created to protect the dignity of every individual. It protects the individual, but not as a separate entity, as part of a greater whole, society. Mrs. Murray is part of society, and she seeks help. She lives with multiple sclerosis, a degenerative chronic disease that leaves her in pain, suffering, and with no other choice to resort to the only remedy available, medical cannabis. Your Honors, this case is not about condemning the illegal drug use, but it's rather about recognizing necessity and suffering. For this reason, the applicants request this honorable court to find the application admissible both under Article 34 and Article 35 of the Convention. With regards to Article 34, the applicant submits that she does qualify as a victim under the Convention. And this is because the state of Zenman has interfered with her private life and peaceful enjoyment of possession through the conviction, imprisonment, and forfeiture of property. With regards to Article 35, the applicant submits that the application should be admissible, as she did clearly exhaust all domestic remedies by going all the way up to the Supreme Court under domestic law. In addition, the applicant did comply with the 4 months rule, and she did suffer a significant disadvantage, not only as an ill woman, but also as a low-income worker, as it will be further analyzed under the merits of the case. In addition, the applicant submits that the application is not manifestly ill-founded because there has been a clear and apparent violations of her right both under Article 8 and Article 1, Protocol 1. If it may please the court, we would now like to proceed and analyze the merits of the case under Article 8 of the Convention. Your Honors, as this honorable court has found multiple times in its jurisprudence, Article 8 sets both negative obligation for the state not to interfere with the right of the applicants and positive obligations to create an effective and functioning framework for the applicant to have her rights protected. Throughout this pleading today, we will analyze both the negative and positive obligations of the state. Starting with the negative obligations, Your Honor, the applicant submits that the conviction, imprisonment, and forfeiture of property imposed by the respondent state of Zenman constituted a clear interference with her rights under Article 8. More specifically, the interference targeted Mrs. Merrier's right to personal autonomy, physical integrity, and quality of life. This is because through the conviction and imprisonment, Mrs. Merrier saw her rights to personal autonomy, physical integrity, and quality of life at stake, as it's proven that diseases such as multiple sclerosis tends to be worsened off in situations of high distress, such as being imprisoned entails. In addition, when it comes to the forfeiture of property, this falls within the right of private life of Mrs. Merrier because the cannabis, the dried cannabis, the plants of cannabis, were the only means that she had to cure the symptoms of her disease in the best way that she deemed fit. Cases such as Christosov and others versus Bulgaria have established that access to medical treatment falls squarely within the right protected under Article 8 of the Convention. According to the court's jurisprudence, any interference under Article 8 must be justified.
Counsel, can I please interrupt you for a second here before we move on to the next part of the analysis? I have a question about the applicability and the victim status. You argued that this is part of personal autonomy. Doesn't personal autonomy stop where criminal law starts? You argued that there's access to treatment. This is not recognized as treatment in the country. The applicant wishes this to be recognized as treatment, but it is not a recognized medical treatment in the country. So why is Article 8 applicable here at all?
Thank you, Your Honor, for your question. Article 8 of the Convention is applicable here because the state failed Mrs. Murray, specifically failed her in protecting her rights of private life by not establishing a functional framework for Mrs. Murray to access alternative medical cures to cure her disease. In addition to that, she qualifies as a victim because she clearly suffered an interference of the state, both under Article 8 and Article 1, Protocol 1. As this court has established, although every interference must be in accordance with the law, must pursue a legitimate aim, and must be necessary in a democratic society.
Sorry, Counsel, again, but coming back on applicability of Article 8. So do you claim that Article 8 encompasses medical treatment choice? Are we witnessing, so to say, a birth of new right to self-medicate under Article 8?
Thank you, Your Honor. As this honorable court has found in Christosov and Andres versus Bulgaria, the right to access medical treatment does fall within the scope of Article 8. And in addition to that, the necessity that Mrs. Maria were presented in front of justifies her need to resort to the only remedy available, the cultivation and use of medical cannabis, because the state failed to fulfill its obligation under the positive obligation set by Article 8 of the Convention, which will further on analyze throughout this pleading. If it may please the court, the applicant would like now to submit that it recognizes the fulfillment of the requirement of lawfulness, as the applicant acknowledges that the interference by the state was based on Article 251 and 255 of the Zemlyan Criminal Code. The applicant also recognized that the measure by the state of Zemlyan did pursue a legitimate aim, namely the aim to prevent disorder and crime and to prevent the illicit distribution of narcotic drugs. However, the applicant challenges the interference of the states of Zemlyan under the requirement of necessary in a democratic society. And this is because the intervention did not meet a pressing social need and was not proportionate. Today, we will analyze both aspects of the interference having to be necessary in a democratic society.
Could I just ask counsel to verify that, if I understand you correctly, it is not the absence or the structure of the legal framework that you are complaining about, it is the proportionality of its application that is worrying you?
That is correct, Your Honor.
Thank you.
In fact, the applicant submits that the interference was not justified by a pressing social need, as Mrs. Murray's actions were clearly dictated by a medical necessity. The use of medical cannabis was limited in scope and not commercially driven. This highly distinguishes from cases where the state might justify its interference because of high quality and high risk of drug distribution and disseminations involved. The applicant therefore submits that the interference of the state did not meet a pressing social need, as the state failed to explain and to provide evidence of how Mrs. Murray's actions will have endangered society as a whole. We will now proceed to demonstrate how the interference was also disproportionate.
Sorry, counsel. I see your logic that it is about necessity and she didn't have another option, if I'm understanding that, but self-treat. But remember that together with this, and she was sharing this with others as well. She didn't limit her actions only by self-treat. That's why I would like to understand your logic about necessity. It is not only about this, but and you include here and that she had right and to disseminate it and to share with others and involve them in this the self-treat issue. That's why they are going together, that hand to hand. That's why. So thank you. You are mostly limited on her only, but she was sharing it with others as well. She was distributing, she's disseminating it with other members of society, knowing that it is forbidden by law.
Your Honor, thank you so much for bringing this up. Although it is true that there is an element of distribution, the applicant submits to this honorable court that distribution of narcotic drugs was limited to only 5 people that were particularly close to the social circle of Mrs. Murray, the applicant. In addition to that, these 5 people took the cannabis willingly as they were suffering similar conditions as Mrs. Murray was. Thirdly, these people testified on having positive effects as a consequence of the use of medical cannabis, which goes back to further strengthen the argument that the state should provide access to these drugs within a functioning legal framework, although this will further be analyzed under the positive obligations of the state. If this answers your question, Your Honor, the applicant would like...
No, sorry. If 5 people, it is okay. If 500, it is not okay. So because if your argument is that only 5 people there were, what is the main argument here? I want to understand. Or it is, regardless how many people were involved, you don't see their problem. Because 5 people or 50 people, what's the difference?
Thank you, Honor.
Sorry, Counsel, just as a follow-up of Judge Arutian question, do you think, so if I understand correctly, as in your diagnosis of disproportionate measure, you are putting inside the fact that it has been disseminating only among 5 people, or even the fact that it's been disseminating in people who are suffering of the same disease or something, or some disease like the one she's suffering?
Thank you, Your Honors, for the questions. I will answer in 2 points, beginning with the fact that the number is relevant, as only 5 people decreases the distribution risk that comes with the distribution of narcotic drugs. But this is not the only element to be considered. And this is because these 5 people were suffering as Mrs. Merlier was. This is a key analysis that we ask this honorable court to consider. And this is because these people were seeking remedies as Mrs. Merlier. And through the use of cannabis, they were seeking relief, and they obtained relief from chronic disease. In addition to that, Your Honors, we argue that the law is disproportionate because even if Mrs. Merlier did not distribute narcotic drugs, she would still have been imprisoned. So even if she had to consume the drug only for personal use, the disproportionality of the application of the law would still be an element to consider. In fact, under Zemland Criminal Code, specifically Article 251 and 255, there is no distinctions between cases of large-scale trafficking and the use of medical cannabis for personal use. As a result, the law contains no safeguard to protect the individuals in exceptional circumstances. It denies this court the ability to individually assess the facts of the case and imposes a punishment in an automatical and inflexible manner. In cases such as Sabancheva versus Russia, this honorable court has found that a law imposing a blanket restriction contravenes the obligations set forth in the convention. Zemland's sentencing and forfeiture operates in a similarly rigid and inflexible manner, making the application of the law disproportionate. In addition to that, Your Honors, even within its framework, Article 100 of the Zemland Criminal Code, which provides to the court discretion to lower the sentence under specific crimes, will have still appeared disproportionate. Article 100 facts allows discretion to the courts in situations of duress, emergency, and to save one's life, among others. Yet, in the case of Mrs. Merlier, this discretion was not exercised. Mrs. Merlier's conduct was largely driven by medical emergency, And the failure to apply Article 100 makes the
Excuse
application...
me, Counsel, you're stressing a lot about this medical necessity for your client, and you're stressing a lot on only 5 people being, so to say, provided with drugs. What about very high social media promotion? That might look less like personal medical use and maybe more as a cannabis, action of cannabis entrepreneur. So what is the turning point from just medical necessity from becoming a promoter?
Thank you, Your Honor. Mrs. Merlier is merely a concerned citizen who exercised her right of opinion by sharing her ideas and her experience on social media. The facts of the case never point out to Mrs. Merlier engaging in illegal activities online, as she was merely exercising her freedom of speech. If this answers your question, Your Honor, the applicant would like to reiterate that Article 100 and the failure to apply it correctly amounts to a disproportionate application of the law. In fact, Your Honor, Mrs. Merlier and her specific circumstances of the case were not sufficiently analyzed by this court. If we contrast the case of the applicant to cases such as Thorn versus Sweden, where the applicant was merely sentenced with a fine of 520 euro, the conviction, imprisonment, and forfeiture of the property of Mrs. Merlier appears highly disproportionate. Domestic law has also failed to consider the jurisprudence of and similar cases of applicants in Mrs. Merlier conditions. If it may please the court, the applicants would like to now move on to analyze the positive obligations of the state under Article 8, claiming that the state failed to provide an effective and functioning legal framework. In fact, Your Honor, it has already been established as Article 8 also sets positive obligation to the state. And the court has previously addressed, in cases such as Christosov and others versus Bulgaria, that having access to medical cannabis is a right protected under the convention, and the state is under the obligation to provide a framework for applicants to access these medicaments. With specific reference to Section 12 on the law of controlled substance, the mere existence of a legal framework does not suffice to fulfill the positive obligation of the state. In fact, a framework has to be effective and functioning. The court has repeatedly emphasized this concept in cases such as Al-Nashif versus Bulgaria, where this honorable court has remarked that a remedy has to be effective and practical, and not theoretical nor illusory. The applicant submits that the case of Section 12 of the law of controlled substance does not fulfill the positive obligation of the states, as per qualification question number 7, this remedy and this exception specifically is not appealable. In addition to that, this is an exception that has never been granted under the domestic law of Zemland. This framework clearly offers no other solution but failure, as it's clearly not effective, not functioning, and it aligns with the zero-tolerance policy of the state of Zemland. In addition to that, the applicant claims that...
Counsel, 1 second, please. I'm having some trouble understanding. What exactly is the positive obligation? Are you suggesting now that Article 8 of the Convention creates a positive obligation for the 46 member states to provide universal access to cannabis as, at least for certain medical conditions? That's a bold claim. And what is the state of the European consensus on this?
Your Honor, thank you for your question. Despite cases such as Christosov and others versus Bulgaria have established that states have a wide margin of appreciation when it comes to regulating their own health policies, the applicant submits to this court that because of the consensus among the member states of the European of the Council of Europe, the margin of appreciation of the state should be restricted and narrowed. Because of this, and because of this consensus among more than 70% of the member states, the states, in this case Zemland, should provide access to medical cannabis, or at least provide an effective and functioning framework for their application for the extraordinary use to medical cannabis. Section 12 does not qualify as an effective remedy because, first of all, it's merely an exceptional application, and in addition to that, it's not functioning as the application has never been granted under domestic law, under the domestic law of Zemland, and in addition to that, it fails to fulfill the requirement of the quality of the law, as it's not appealable.
I'm sorry, but the fact that something has never, there's always the first time. If people do not try to apply for the exemption, then how can we ask the state to prove that it's never, people have to ask in order to create the practice and the jurisprudence. Did she ask for the exemption in this case?
Thank you, Your Honor. Mrs. Merlier did apply for the use of medical cannabis under Section 12, and she was denied access. The fact that only 3 people applied to this remedy is significant because in 3 cases, the opinion of the panel of experts aligned with the zero-tolerance approach of the state of Zemland. This mirrors a willingness not to allow the use of medical cannabis under domestic law. In addition to that, the applicant would like to reiterate.
Apologize, Counsel, against one more question that it is a sort of follow-up. According to the facts of the case, during the first instance procedure, it has been shown a research that was inconclusive as to whether the use of medical cannabis should be recommended for the clinical management of chronic pain. So my question is the following. Do you think that the fact that around about 70% of the European state, of the state member of the Council of Europe, there is some legal framework according to which the use of medical cannabis is allowed? Do you think that because of the fact of this case, the wide margin of appreciation that our case law in the Bulgarian case allows to the state could be affected?
Yes, Your Honor. Thank you for your question. In order to answer your inquiry, I'm going to first refer to, once again, the general consensus, and I will then proceed to analyze convention and research that testify upon the necessity to allow the use of medical cannabis. Beginning with the general consensus, the applicant would like to reiterate that 32 out of the 46 member states of the Council of Europe allow use of medical cannabis. This is significant because this court found that where there is a clear European consensus, the margin of appreciation of the state can be narrowed. In addition to that...
So excuse me, just to interrupt for a second. Are you talking about access to medical cannabis in general, or is it access to medical cannabis specifically for the purpose of patients with multiple sclerosis? Or is there any difference?
Thank you, Your Honor. We are claiming that the access of cannabis based on a European consensus should be accessible to mitigate all diseases or the symptoms of every disease as prescribed by the UN Convention on Narcotic Drugs.
That I was wondering whether the consensus you're talking about, whether the 70% member states provide access to medical cannabis in general, or whether this is explicitly for purposes of multiple sclerosis.
They do, Your Honor, in general and also with regards to multiple sclerosis. The applicant would also like to submit to this honorable court that even in cases such as Thorn versus Sweden, the access to medical cannabis specifically for multiple sclerosis was allowed at the time of the proceedings. In addition to that, the applicant would like to submit to this honorable court that jurisdictions such as the Czech Republic allow for an amount of 180 grams of medical cannabis a month for multiple and different classes of diseases. Mrs. Merlier, according to the facts of the case, was found in possession of only 100 grams of cannabis, which appears to be way below the limit and the amount that is allowed in jurisdictions such as the Czech Republic.
Counsel, since you mentioned Thorn judgment, can you distinguish your case from Thorn versus Sweden, given the court there found non-violation despite criminal conviction for unauthorized cannabis use?
Thank you, Your Honor. The applicant would like to submit that in the case of Thorn versus Sweden, the fine imposed to the applicant was of merely 520 euros. In this case, even if Mrs. Murray was found not to distribute cannabis and to use it just for a personal limited scope, she would still have incurred in imprisonment. As already mentioned, in addition to that, the state failed to properly apply Article 100 and consider the specific circumstances of the case. This honorable court in Thorn versus Sweden also established that Mrs. Thorn's condition of chronic pain and severe distress justified the use of medical cannabis. Lastly, Your Honor, in the case of Thorn versus Sweden, the court, for the time of the proceedings, still allowed Mrs. Thorn to use and consume cannabis until the court found and ruled in favor of the respondent. If this answers your question, the applicant would also like to submit that conventions such as the UN Convention on Narcotic Drugs testifies on the benefits of cannabis for medical use and ask the states to provide an effective and functioning legal framework to allow the use of medical cannabis. If it may please the court, the applicant would like to ask your honors to find that there has been an omission under the negative obligation of under Article 8 and the positive obligation of under Article 8 and a failure to protect Mrs. Murray's rights under Article 8 of the Convention. I will now leave the floor to my co-counsel who will analyze the merits of the case under Article 1, Protocol 1.
May it please this honorable court, my name is Claudia Espinosa, and on behalf of the applicant on this matter, I shall now be addressing the merits of the claims brought under Article 1, Protocol 1 to the Convention. Before addressing the arguments, nevertheless, the applicant would like to first consider the scope of this article. Article 1 of Protocol Number 1 recognizes the right to property, ensuring that all individuals have the right to peacefully enjoy, use, develop, and dispose of all their existing possessions. In this case, Ms. Marlier's land, dried cannabis, 6 cannabis plants, and money in her bank accounts all constituted existing possessions of the applicant. Therefore, the forfeiture of these assets by Semlin clearly constituted an interference with Ms. Marlier's rights. Drawing from precedent of this court, the interference should be classified as control of the use of property, despite the obvious fact that they entail a permanent deprivation of her possessions, as seen in cases such as Agosti versus the United Kingdom, Raimondo versus Italy, Honecker and others versus Germany, or Butler versus the United Kingdom. The interference thus falls under the second paragraph of Article 1, Protocol 1, which recognizes the rights that states have to control the use of property in the general interest if provided for by law. Nonetheless, the applicant submits that the interference with Ms. Marlier's rights is not justified because the requirements of lawfulness and proportionality were not met. Before addressing these two requirements, the applicant would like to first consider the second requirement not mentioned, that of legitimate aim. According to case law of this court, the aims of combating drug trafficking and preventing disorder and crime are legitimate aims. Therefore, the applicant understands that Semlin's actions were driven in pursuit of these aims and will not contest its legitimacy. Instead, the applicant argues that the interference was not justified as it was not provided for by law, nor was it proportionate to the legitimate aim sought, constituting a violation. Regarding the first requirement, that of lawfulness, this requirement should be understood as the phrase "in accordance with the law" found in other articles of the Convention, which presupposes that the law should be accessible, precise, and foreseeable. However, the provisions that regulate forfeiture in Semlin's Criminal Code, particularly Article 255, lack foreseeability given its automatic and compulsory application upon drug trafficking. This is because the courts are not able to decide whether to impose forfeiture as a sanction or not. Regardless of the consequences of the case and regardless of the individual circumstances of Ms. Marlier, forfeiture will always apply. Established in Marcus versus Latvia, this leaves such uncertainty about the trial court's competence that the applicant could not have reasonably foreseen all the extent of the forfeiture and all the assets that she was subject to confiscation, particularly, for instance, the forfeiture of the 20,000 euros from Ms. Marlier's bank account and her land.
Excuse me, counsel.
No, please go ahead.
May I just ask a question? Your co-counsel indicated that the interference was lawful, and now you're saying that forfeiture will always happen when there's a prosecution, and at the same time you're saying that this is not foreseeable, if I understand. Could you clarify your explanation, please, about the lack of certainty regarding the legislation there?
If I can add to that question, which is in the same domain, I understand that the criminal law of Zemland makes no secret about the fact that the possession and cultivation of cannabis is illegal, and yet you claim that the measure of bringing forfeiture to the land where cannabis was grown came as a surprise to the applicant. Could you please elaborate upon that?
Of course. Thank you, Your Honors. I would first address the first question. Regarding the foreseeability of forfeiture, it is true that forfeiture was clear as a sanction for drug trafficking. However, the applicant claims that the extent of the forfeiture was not foreseeable. This is not just a problem of proportionality, which links to the second question. However, it is also a problem for foreseeability, as the applicant was not convicted of selling, but nevertheless, she was subject to the forfeiture of 20,000 euros from her bank accounts. Regarding the second question, regarding the proportionality of essentially the measure, the applicant claims that the problem lies in the fact that the domestic courts failed to consider the individual circumstances of Ms. Marlier. No consideration was given to her chronic illness, her low-wage job, the severe economic impact that losing her assets would have on her, and more importantly, her behavior and lack of criminal intent. This links to the third requirement, that of proportionality. So if this answers Your Honor's questions, I would now move on to that requirement. As for Article 8, the applicant contends that the interference, in this case the forfeiture, was not proportionate as it imposed an excessive burden on the applicant, failing to strike a fair balance between the individual rights and the general interest. I will address the requirement of proportionality through three main points. First of all, with the lack of consideration of individual circumstances of Ms. Marlier, which I mentioned previously. Secondly, regarding the disproportionality of the offense, of the sanctions, compared to the low severity of her actions. And lastly, regarding the existence of less intrusive measures. As mentioned, by applying forfeiture blindly, the state failed to strike a fair balance between the interests of Ms. Marlier and the general public, which makes the interference disproportionate and unjustified. This excessive burden links to my second point, proving that the domestic courts in Zemland failed to comply with the principle recognizing the case of Griffhurst versus France, which establishes that the severity of the sanctions must be proportionate, to the seriousness of the offense. In this case, Ms. Marlier is diagnosed with multiple sclerosis and suffers unbearable constant pain. There's no cure to her illness, and there's no effective remedy either in her country, so she turned to cannabis. And for that, Zemland responded by subjecting the applicant to the forfeiture of her remedy, everything she had, all her savings on top of her land, in addition to being deprived of her liberty, considering her low severity of her actions. The forfeiture of these four elements must be analyzed as a whole, as it is taken together that the sanctions become disproportionate given the excessive burden that they impose on the applicant. Regarding the last point about the forfeiture of Ms. Marlier's money, before addressing the point, nevertheless, I see, Your Honors, my time is running out, so I would like to request 1 additional minute to conclude my pleadings. Thank you. As I mentioned, regarding the third forfeiture, that of the 20,000 euros from Ms. Marlier's bank accounts, the state of Zemland claims that they are forfeited because they represent proceeds of crime. Nevertheless, the state did not at any point prove that Ms. Marlier had sold cannabis or had received any type of monetary compensation in exchange for the substance. Ms. Marlier was convicted of giving the substance away for free to other people who were in similar circumstances as her and were in need of pain relief. she was not convicted of selling. There's no mention of selling in the judicial assessment. Therefore, that the respondent cannot now come back and say that the 20,000 represent proceeds from crime and profits from something that she did not do. It represents a contradiction with its own judicial assessment.
Excuse me, counsel. I think it's indicated that the Supreme Court noted that the applicant had been selling cannabis.
Your Honor, the facts of the case, if I'm not mistaken, in paragraph 21, make reference to selling, but not directly by the applicant, but by third persons related to the applicant. Therefore, those are not the actions that we're concerned about today, because they're not by Ms. Marlier, they're by other people's, and therefore we cannot judge on them. This crucial distinction between selling and given was ignored, which renders the sanction disproportionate. Lastly, the applicant would like to submit that the disproportionality of the sanctions, compared to the low severity of her actions highlights the failure of Semlin to impose less intrusive measures in her case. In conclusion, the state's interference was excessive and fundamentally unjust, as they imposed a disproportionate burden on Ms. Marlier by failing to consider her unique circumstances and disregarding essential procedural safeguards. Semlin has violated Ms. Marlier's rights under Article 1, Protocol 1 to the Convention. This is why the applicant respectfully requests this court to declare the application admissible under Article 34 and 35 of the Convention, and adjudge that the respondent has violated Ms. Marlier's rights under Article 8 and Article 1, Protocol 1. The applicant also requests this court to award just satisfaction under Article 41 with respect to the applicant's pecuniary and non-pecuniary damages and order the reimbursement of the full costs and expenses incurred. Thank you very much.
Thank you, counsel. Now I give the floor to the respondent states. Timekeeper, you can start.
Dear Mr. President, honorable members of the court, the respondent submits that the application of Mrs. Marlier is partially inadmissible for the following reasons. To begin, we believe that the applicant's argumentation concerning Article 8 of the Convention breaks into two separate complaints. The first one concerning the applicant's conviction for trafficking and cultivation of cannabis. The second complaint concerning the alleged deficiencies of the Semlin's framework governing access to medical cannabis. In our opinion, such distinction is important for the assessment of the admissibility. Firstly, we believe that the applicant's complaints concerning her cultivation and trafficking of cannabis are inadmissible as they are incompatible ratione materii of Article 8 of the Convention. We acknowledge that in the case Thorn versus Sweden, the court has held that cultivation of cannabis, which serves as a medical treatment, falls within the scope of Article 8 of the Convention. However, Mr. Thorn was cultivating cannabis exclusively for his personal use. And under these circumstances, the court has held, yes, Mr. Thorn has a right to choose and cultivate cannabis to treat his health condition. On the other hand, the applicant's case does not only concern cultivation for personal use, but also trafficking of cannabis and cultivation and possession of major amount of cannabis. The applicant herself admitted during the domestic proceedings that she has provided cannabis to other persons, and it was established that other persons related to the applicant had sold cannabis. And yes, the applicant would have been sentenced regardless of the trafficking. However, as was held in the case Hristosov and others versus Bulgaria, the court cannot review the domestic law in abstracto, but only in a manner in which it has been applied to the applicant. And the Semlin's criminal law was applied to the applicant in a way that she was convicted for drug trafficking and possession of major amount of narcotics. These provisions clearly do not interfere with applicant's right to choose a way to treat her health condition. They pursue a different legitimate aim, a protection of society against dissemination of narcotics. Therefore, we believe that the conviction did not interfere with applicant's rights under Article 8 of the Convention, and therefore her complaints in this regard are incompatible ratione materii.
Counsel, can we stop here for a second, please? So you're making points, bifurcated sort of arguments about her personal use and distribution to others, but let's stop at the personal use because that's the core issue here. Now, if I look at Thorn versus Sweden, which was decided only a few years back, there's a single paragraph on this under admissibility, paragraph 37. It seems so obvious to the court here that the Article 8 is applicable that there's not even any much discussion. There's no contestation by the respondent government in that case. So on what basis would you claim here, looking at personal use, that even that does not fall under Article 8?
Oh, thank you for the question. As I've addressed, we believe that the applicant and Mr. Thorne has a right to choose a medication to treat his health condition, including cannabis, and for this purpose to cultivate it. However, the applicant was also trafficking it to other persons. And while we acknowledge the altruistic motivation of the applicant, we believe that her conduct still falls outside the scope of Article 8 of the Convention. Firstly, the applicant is not a medical expert, and therefore she could not assess the medical necessity and the risks of providing cannabis to other persons. Secondly, we do not know if those other persons were in the same situation as the applicant. For example, whether they exhausted all treatment available in the state of Zemland, or if they, for example, applied to medical cannabis through the compassionate use framework. It is actually stated in the case facts, paragraph 12, that the applicant provided the cannabis to at least 5 persons. As is apparent from the answer to the clarification question number 17, only 3 requests were submitted through the compassionate use frameworks. Therefore, we can see that not all the persons that obtained cannabis from the applicant did not even try to obtain cannabis through the framework. And therefore, we believe that the applicant, being not a medical expert, cannot substitute the state, the healthcare system of the state in this regard. If I may proceed, secondly, we believe that the applicant's complaints concerning the alleged deficiencies of the Zemland's framework are inadmissible, as the applicant failed to comply with the 4-month time limit within the meaning of Article 45, paragraph 1 of the Convention. It is apparent from the answer to the clarification question number 26, the applicant has applied to access medical cannabis through the compassionate use framework, and her request was dismissed. This happened a couple of years before the applicant lodged the application to the court. And it was the consequences of this decision that she was finally unable to obtain medical cannabis legally. And we believe that if she thought that the framework does not adhere to the requirements of the Convention, she should have lodged the application within the 4 months time limit from the day of this decision. To conclude, we believe that the applicant's complaints concerning Article 8...
Sorry, Counsel. So taking into account that she was in the situation when it isn't, in some sense, a question of her dignity as well, to relieve, to reduce this pain, and she didn't have any option but to use this. And it is obvious that there weren't other members of society in this. Don't you think that there was a pressuring social need to envisage by legislation exceptional options, like 70% of other member states, whether there were not here something like social pressuring need for this?
Well, we believe that there might be a case, but if the applicant thought so, she should have applied within the 4 months time limit from the decision, or at the time the compassionate use framework was adopted in 2022. Instead of this, she started to commit criminal offenses. Therefore, we believe that she did not adhere to the requirement of the 4 month time limit. To conclude, we believe that the applicant's complaints under Article 8 of the Convention are inadmissible in their entirety. As to the applicant's complaints concerning Article 1, Protocol number 1 to the Convention, we do not have any comments in this regard. Now I shall pass the floor to my colleague to address the merits. Thank you.
Mr. President, honorable members of the court. By way of introduction, I would like to repeat that the application should be considered inadmissible insofar as was explained by my co-counsel. Now, I would like to also reiterate that the application should be broken down into 2 separate issues. First of them is tied to the positive obligations, the compassionate use framework, whereas the second one is tied to the criminal proceedings against the applicant. If it pleases the court, I would like to begin with the positive obligations. And by analyzing the decising procedure of the Ministry of Health. Now, the sole fact that the case of the applicant is one of the first cases decided by the Ministry does not necessarily mean it is arbitrary or manifestly unreasonable, as was held previously in the cases such as Satakunnan Markkinaporssi Oy and Satamedia Oy against Finland or Kudravicius against Latvia. Secondly, in the case of Gudmundur Gunnarsson and Magnus David Nordahl against Iceland, the court was previously ready to accept a reasonable explanation with regard to the absence of case law regarding these remedies. Now, the respondent is prepared to offer these explanations. First of all, we are talking about a relatively novel institute, which was only established in the year of 2022. We believe that this explains that there could be only a limited number of cases decided. Secondly, this institute has an exceptional nature as it allows access to possibly illicit and possibly dangerous substances which are not registered in Zemland, such as cannabis. If it pleases the court, we believe that the legitimate aim of this framework is quite apparent, as it is the protection of public health. Now I would like to proceed by assessing the proportionality of this framework. Now the respondent would like to stress that the state has to be afforded a wide margin of appreciation when we are talking about matters linked to the healthcare policy of the state. Now this was repeatedly held by this court in cases such as Thorn against Sweden, Wawrzyczka and others against Czech Republic, Abdushev and others against Russia, etc., etc. Now the applicant was disputing that there is certain emerging consensus within the Council of Europe. To this regard, we would like to state that in the case such as Thorn against Sweden or AM and AK, and both of these cases are relatively novel, AM and AK is from the year 2017, whereas Thorn against Sweden is from 2020, the court has not found an emerging trend and has not narrowed the margin of appreciation based on this. Finally, even if the court was not convinced by this argumentation, we would like to submit that in the case of Abdisheva and others against Russia, the court has held that the emerging consensus is merely one of the factors which have to be assessed when we are talking about the wide margin of appreciation, and it is not necessarily the decisive one. Now, to this regard, we would like to point out to various other factors which determine that there should be a wide margin of appreciation afforded to the state. Firstly, there is an important moral and ethical element present in this case, which becomes more apparent when we take into account that there are various risks tied to cannabis use, abuse, and its dissemination within the society of Zemland. Firstly, there are various risks such as development of schizophrenia, psychosis, and increase of crime. This is quite apparent from the documents provided by United Nations Drug and Crime Agency, which I would like to refer to. Secondly, there is another factor which shows that the margin of appreciation has to be wide, as the state is required to strike balance between the competing public and private interests. Since this matter is again tightly linked to healthcare policy, we believe that the general interest of the state on protecting its citizen has to be prevailing. Finally, in case that the court is not convinced by this argumentation, in the case of Hristosov and others against Bulgaria, this court has held, and I would like to cite the paragraph 126, that it is not in itself contrary to the convention for a state to regulate important aspects of private life without making provision for the weighing of competing interests in each individual case.
Counsel, in Thorn, Sweden had licensed an alternative legal medication for the applicant during the proceedings. Now, Zelmond appears to offer no alternatives, no compassionate use exception was granted. And my question is, how does this complete absence of any alternative affect your margin of appreciation?
Thank you very much. Firstly, we believe that there indeed was an alternative. We believe that the compassionate use framework is effective and functional. Secondly, we would like to again stress that there has to be a wide margin of appreciation regarding the healthcare policy. Finally, we believe that the margin of appreciation is a concept which precedes the action of the state. Thus, it delineates the playing ground, so to speak, of the state, and the state then has to maintain its conduct within this playing field, which we believe was indeed the case in the case of Marlier against Zemland.
Can I come in for a second, please? Because I'm hearing somewhat what appear to be somewhat inconsistent arguments. As a yes or no question, does your government, is the position of your government, do you accept that the use of cannabis by an applicant with the applicant's condition as a pain relief treatment is beneficial in a way that no other medical treatment provides in your country? It's a yes or no question.
No.
Is the pain relief provided by the cannabis medication that the applicant using superior to any other options she had at the relevant time? It's a yes or no question.
Yes.
Okay. And secondly, was the compassionate relief, I've seen some conflicting factual claims here, was the compassionate relief option used, and did it constitute an effective remedy in the case of this particular applicant?
We believe that it is the case, yes.
Thank you.
Thank you, Your Honor.
Can you elaborate on your last response, why you believe that was the case?
Should I elaborate on why we believe that this is indeed an efficient measure?
The specific case of the applicant.
We believe that in the specific case of the applicant, the ministry has indeed taken into account the severity of her health and her individual situation. As is apparent from the case facts, the ministry has provided a succinct reasoning as to why she should not be afforded this. Finally, we believe that in regards to this, the applicant has failed to meet the 4-month time limit, as was previously explained by my co-counsel. Now, if it pleases the court, I shall proceed to analyze the criminal proceedings against the applicant. Now, firstly, I would like to begin by the points of agreement. There is no dispute as to the legal basis and to the legitimate aim pursued by the state. Finally, it has to be analyzed the proportionality and the margin of appreciation in this case again. Again, there is a tight link to healthcare policy, as there are various tools which are used to safeguard it. Firstly, there is administrative law, and in the cases which are where there is a severe breach of this law, criminal law has to come in play. Now, I've already talked about the wide margin of appreciation in regards to healthcare policy. We also believe that when it comes to criminal law policy, the margin of appreciation should be wide, as was held, for example, in TAS against Belgium. Now, there are also apparent sensitive and moral issues linked to this case, as there is a strong there is a strong anti-drug and anti-cannabis sentiment present within the state of Zemland. Now, this is apparent when we take into account Article 51 of the Constitution of Zemland, which states that drug abuse should be prevented by all possible means. Now, this consensus was further reaffirmed on the grounds of the National Parliament of Zemland, which has rejected law that could ease access to illicit substances. Finally, we believe that the state should be afforded wide margin of appreciation, as it was also weighing the competing interests of the state and of the individual. Finally, when we analyze the approach of the courts towards the applicant, we believe that they have actually taken into account her disorder, the severity of her situations, which is apparent from the case facts 20 and 21. Now, they have also dealt with the objections regarding the application of Article 100, as they have applied this article in line with the national case law, which is settled that this article comes only into play when there is a direct and immediate threat to the life of the applicant, which the courts have not found in this case. Therefore, we believe that these decisions were not arbitrary nor manifestly unreasonable. Finally, when we analyze the punishment imposed upon the applicant, it has to be taken into account that the maximum statutory range is 10 years in prison, which again points towards the strong stance of Zemlandic society when it comes to combat against drugs. Now, the courts have balanced these interests and have imposed a punishment within the lower half of this statutory range, as the applicant was only sentenced to 2.5 years. And in this regard, we have to stress that the applicant has trafficked cannabis to 5 other persons, and thus she has put the risks linked to cannabis upon them, and she was furthermore in no position to analyze their health condition. Now, I hope this pleased the court, and I would like to pass the floor to my colleague. Thank you very much.
Before you do, can I just ask you to clarify? You were just explaining how the application of Zemland law in the courts balanced the different interests at stake in this piece of legislation. Now, if memory serves me right, the amount of cannabis that the applicant was apprehended with is the equivalent of what is less than the permissible monthly quantity for medical purposes in the Czech Republic, and yet she is sentenced to a quite severe prison sentence. Could you please elaborate on how this actually balances the different interests at stake?
Thank you very much for the question. I would like to use a minute to think about the answer to this question, if it pleases the court. We have to state that in this regard, there is a strong interest on preventing trafficking of cannabis. And to this regard, the state has thus imposed this punishment. I hope it satisfies the court. And now I would like to yield the floor to my colleague. Thank you.
Dear Mr. President, honorable members of the court, I will now address the alleged violation of Article 1 of Protocol number 1 to the Convention, arguing that the forfeiture of the applicant's property was consistent with the requirements of this article as interpreted by this honorable court, for example, in case of Baylor v. Italy, because it was A, prescribed by law, B, it pursued a general interest, and C, it struck a fair balance between the general interest of society and the interest of the individual concerned. Now, before coming onto this three-pronged test, we would like to make a couple of remarks. First point of agreement with the applicant is that the land and the sum of 20,000 euros do indeed constitute possessions within the autonomous meaning of the term under Article 1 of Protocol number 1 to the Convention as interpreted by the court, for example, in case of Parello v. Italy. Now, second point of agreement, we do not dispute that there was an interference with the free enjoyment of these two assets, namely in the form of imposition of auxiliary penalty of confiscation of these two assets. Now, coming on to the third point of agreement, we as well agree that this interference should be considered under so-called third rule or second paragraph of Article 1 of Protocol number 1 to the Convention, because although it leads to permanent deprivation of the property and the possession, this court has repeatedly stated, for example, in case of Phillips with the United Kingdom or Georgievich with the United Kingdom, with France, that when it comes to the imposition of a criminal penalty or a forfeiture order when it comes to the proceeds of the crime, it constitutes a control of use of property in the general interest. Now coming on to the three-pronged test. First is the requirement of lawfulness. Now, the applicant does not dispute that there were legal bases when it comes to the forfeiture order, namely the Article 255 of the Criminal Code. What the applicant actually disputes is that this article was foreseeable. We believe that although this article really bestowed upon judges quite a wide discretion when it comes to the amount and the extent of the property that can be confiscated under this article, we believe that this satisfies indeed the requirement of foreseeability for three reasons. First, as this honorable court held in Di Stefano v. Italy, it is not required under the requirement of foreseeability that the consequences that given provision may entail need to be foreseeable with excessive rigidity. We believe that it is especially important when it comes to a confiscation order, because during imposition of confiscation order, the domestic courts have to be able to take the circumstances of the case into account, and that is exactly what this provision allows. Now, the second reason why we believe that the provision is actually foreseeable is the fact that this court has repeatedly held that the foreseeability of given provision is intertwined with procedural safeguards. And now we believe that in this case procedural safeguards were present because the entire criminal proceedings was governed by Article 6 of the Convention, both civil and criminal limp. The applicant had possibility to appeal against the decision. She availed herself of that possibility, as is clear from paragraph 17 of the facts of the case. And now third and most important reason why we believe that this provision is actually foreseeable is that this court has held cases regarding confiscation of property based on similar kind of provision. For example, in case of Georgievich v. France, the confiscation order was imposed based on Article 450 of French Criminal Code, which states, and now I cite, Your Honors, natural and legal persons found guilty of the offenses provided for also incur the additional penalty of confiscation of all or part of their property. So when it comes to the discretion of the French courts in those cases, it is as wide as it is in case of Zemlin. And this court in that case held that the requirement of lawfulness was fulfilled. The applicant relied on the case of Marcus v. Latvia. And it is true that this honorable court has held in that case that the forfeiture order imposed by Latvia did not comply with the requirement of foreseeability. However, the reason for that was not that there would be some vague provision, but it was due to the fact that there was conflicting case law when it comes to the amount and extent that should be forfeited. Therefore, we do not believe that our case is equivalent in that respect. When it comes to the automatic nature of the penalty, it is true that this
can I interrupt you for a second? So you've cited some line of case law. I don't know if you're familiar with the line of Bulgarian confiscation case law, Yordanov and other cases.
Yeah.
What the court requires in that line of case law in similar circumstances is a link between the crime and the asset being confiscated. Now, I can see the link between the crime and the actual proceeds, the cannabis, the land. Can you explain to me what is the link between the crime and the amount confiscated in the bank accounts? And how has the prosecution in this case established that link? What is the connection there?
And sorry, as additional to this, because this follow-up question, because national institutions, they didn't even examine the origin of this money. And they didn't show this causal link on the one hand. On the other hand, because of automatic application, applicant even didn't have possibility to present some proofs about origin of this money in order to try to show that this money does have nothing to do with disseminating of cannabis.
Thank you.
I had one more question on the subject as well. So the position of the government, as far as I understand, is that the confiscation order of 20,000 euro, it is a criminal sanction and not a restorative or preventive one. Just yes or no?
Yes, Your Honor, we do believe that it is auxiliary penalty imposed in the criminal proceedings, similar to the cases regarding France, Georgievich v. France or Laurier v. France, and it is not only administrative order, as for example, when it comes to the United Kingdom, where the confiscation order is actually imposed in a separate administrative proceeding. This court has, however, held, in case of Georgievich v. France, that the confiscation order, when it is criminal sanction, it can even tackle the money that is actually not proceed of the crime. So it can be partly punitive. It can partly serve as a punishment. Now, when it comes to the line of Bulgarian cases, we are aware of the cases Todorov and others v. Bulgaria, Mandev v. others and Bulgaria. However, we believe that there was such a causal link, actually. The court in those cases held that a causal link can be actually even presumed, because in one of those cases, in Todorov, it was case of Katsarov v. Bulgaria. Mr. Katsarov was actually convicted only for possession of cannabis with intent to sell, and the prosecution didn't provide any further evidence that Mr. Katsarov actually sold the cannabis, and this honorable court held that it was possible when it comes to the cannabis-rated regulated offenses to even presume such a causal link. However, in this case, it was actually established by the domestic courts, as is clear from paragraph 13 of the facts of the case, that it was highly likely that it constituted proceeds of the crime. So we obviously do not have the entire reasoning of the domestic courts, but the domestic courts arrived at the conclusion that it is highly likely. Now, when it comes to the proportionality assessment, if I may skip, I will skip to the proportionality assessment since those questions considered.
Just one simple question. When you say highly likely, there must be a connection in time, the nature of the offense, the amounts of money, what makes this highly likely? A question of time. How long had this money been in that account? We know that the cannabis business started at a certain point in time. That is a very basic assessment. When was the money in the account and how did it grow over time?
Your Honor, this court has repeatedly held that when it comes to the confiscation of proceeds of the crime, it is actually considered as a sentence, and only the civil limb of Article 6 applies. Therefore, the standard of proof when it comes to the proceeds of crime is not beyond reasonable doubt, as it is when it comes to the guilt of the applicant. In cases such as Phillips v. the United Kingdom and Georgievich v. France, this court held that it is possible for states to even rely on presumptions, and that it accepted the UK procedure where the standard of proof was actually on preponderance of evidence. And we believe that, as this court stated in Todorov and others v. Bulgaria, that this court is ready to defer to the findings of the domestic courts when it comes to the origin of money, if it is not A, manifestly unreasonable, and B, arbitrary. Now I would like to prove that it is actually not arbitrary when it comes to the sum of 20,000 euros. Because as is clear from the facts of the case, the applicant has actually cultivated 20 cannabis plants in a period of 3 years. Now, average yield of one cannabis plant is, according to study published in Nature, renowned scientific magazine, is 100 grams of dried cannabis. Now, if we do the calculation, the applicant in the period of 3 years could have harvested 2,000 grams of cannabis. So although in Czech Republic it's maybe legal to be in possession of 180 grams of cannabis, however, the applicant could have possibly harvested 2 kilos of cannabis. Now, we do not have exact information when it comes to the average price of cannabis on the black market in the state of Zemland, obviously, but we do have that information pertaining to states with similar cannabis regulations, such as Hungary, Slovakia, and Czech Republic. UN Office on Drug and Crimes published in 2024 report on drug and crimes, where it stated that in those 3 states, the average price of 1 dried cannabis gram on the black market in those countries is 10 euros. So actually, if we do the calculation, obviously it hasn't been established beyond reasonable doubt, Your Honor, then the sum of 20,000 euro is not unreasonable. Now, we believe that the second reason why this court should consider the penalty proportionate is that the applicant actually, during domestic proceedings, did not even claim that the money had licit origin. If you look at paragraph 16 and 17 of the facts of the case closely, the applicant only stated that the confiscation order would leave her in economically vulnerable situation. She could have easily proven licit origin of that money. She could have provided bank statements, she could have witnesses, and she didn't do that, and she didn't even appeal. In her appeal, she didn't even state that it had a licit origin. Now, when it comes to case of Griffhort v. France, that was cited by the applicant, it's true that in that case, this honorable court stated that when it comes to the punitive part of the confiscation, it shouldn't leave the applicant in economically vulnerable situation. However, if we look at the conduct of Mr. Griffhort and the applicant in this case, those conduct are widely different. Mr. Griffhort actually only traveled with money to France and forgot to declare it at customs. It was concretely 243,000 euros that he forgot to declare. And the entire sum was confiscated, plus financial penalty of 130,000 euros was imposed on him. We believe that the conduct of Mr. Griffhort cannot be equated to drug trafficking in this case. Although the applicant repeatedly claimed that it hasn't been proven that the applicant actually trafficked drugs, it was proven. She was actually found guilty of giving drugs to others for free. And when it comes to the interest of the state, it doesn't really matter if the applicant gives the cannabis for free or if she actually sells it, because it's still disseminated throughout the population. Now, I would like to briefly address the automatic nature of the sanction, and for that purpose, I would kindly ask you for additional 3 minutes. Thank you. Now, when it comes to the automatic nature of the sanction, it is true that this honorable court has repeatedly held in cases such as GIME and others v. Italy, and in case of Mr. Andonovsky v. former Yugoslav Republic of Macedonia, I'm sorry, Your Honor, that the automatic nature of sanction imposes on the applicant excessive burden because he has no way to defend himself or herself against such a sanction. However, those two cases differ in two significant aspects from the cases of the applicant. Mr. Andonovsky and the company GIME were third parties. They were not parties to the criminal proceedings, and therefore they couldn't appeal against the decision, and therefore they had no possibility of success, unlike the applicant in this case. She actually appealed against the decision, and she had that possibility of access. And secondly, in those two cases, actually, the nature of automaticity of that sanction was actually not only when it comes to the form of the sanction, namely the forfeiture, but as well the amount and extent to be forfeited. Therefore, the courts in those two cases couldn't conduct the proportionality analysis. The courts in Zemlin could conduct the proportionality analysis thanks to the Article 255, which allowed so. Now, if it pleases the court, I will proceed to our conclusions. First, we submit that the application of Mrs. Adelmalie is inadmissible under Article 8 of the Convention for two reasons. First, the applicant has failed to comply with the 4-month time limit specified in Article 45 of the Convention. It is clear from the fact of the case that she applied for the exceptional use of cannabis in early 2022 and submitted the application at the end of 2024. This does not constitute so-called continuing situation as interpreted by this court, for example, in cases of Parillo v. Italy or SAS v. France. Because in those cases, so-called continuing situation cases, the interference emanates directly from the legislation. However, in this case, the interference or alleged interference was consequence of the particular decision of the Ministry of Health. And as this court has held in Posti and Rako v. Finland, legal consequences of a decision over time do not create continuing situation. And therefore, we submit that to this part, when it comes to the positive obligations of the state, the application is inadmissible due to non-compliance with 4-month time limit. Now, when it comes to the criminal conviction, we believe that the conduct of the applicant, namely trafficking in drugs, falls outside of the scope of Article 8. Article 8 protects respect to the private life of the applicant. We believe that in cases such as Thorn v. Sweden, the applicant exercised that right by growing cannabis only for himself. However, as I have proven, the amount of cannabis that the applicant actually possessed, together with giving it to others, implies that she actually didn't cultivate it only for herself and for her own purposes, but as well to distribute it. We believe that that falls outside of the scope of notion of private life. Therefore, we submit that the application in its entirety under Article 8 of the Convention should be declared inadmissible. Now, coming on to the conclusion regarding our argumentation to the merit when it comes to Article 8 of the Convention. Now, when it comes to the positive obligations of the state, we believe that states enjoy wide margin of appreciation, as was stated, for example, in Hristosov. Although the court considered some emerging consensus when it comes to compassionate use framework inside of Council of Europe, it as well stated in Hristosov that those frameworks have more in different than in common. Therefore, we believe that the framework of the applicant falls within the wide margin of appreciation that the states enjoy. Even if this court would consider the compassionate use procedure deficient, we believe that even the rest of the framework without the compassionate use procedure would fall within that margin of appreciation, because as the court stated in Hristosov, it is not contrary to Article 8 of the Convention to regulate certain aspects of private life in general. Now coming on to the criminal conviction of the applicant, we believe that although in the case of Mr. Tone the penalty was far more lenient, as the applicant alluded to, the conduct of the applicant in this case cannot be equated to the conduct of Mr. Tone for aforementioned reasons. The court took into account the state of health of the applicant, as is clear from the facts of the case. The Supreme Court stated that it did not raise any human rights issues for the reasons that we alluded to, because the Supreme Court actually believed that the conduct of the applicant was ratione materi incompatible with Article 8, because the proceedings was about the distribution of cannabis. We cannot speculate what would actually happen, as the applicant did, if she didn't give cannabis to others. Domestic courts in that situation may apply, for example, Article 100 of the case. It is not the role of this court to examine the legislation in abstracto, but how it was applied to the applicant in a particular case. Now coming on to the Article 1 of Protocol number 1 to the Convention, we submit that the forfeiture order was imposed based on domestic legal provision that satisfies all three material requirements of lawfulness. Namely, it is precise, it is foreseeable, and it is accessible. And lastly, we submit that the confiscation order was proportionate. Thank you, Your Honors.
Thank you, counsels. Now the floor is again to the applicant teams for the rebuttal. You have the floor, please. Asking the timekeeper to take into account the extra time granted to the other team. Thank you.
Thank you, Your Honors. Your Honors, if I may, imagine not being able to shower on your own, not even being able to hold your own cup of coffee due to the fear that your arms and legs might spasm and shoot out uncontrollably. Imagine being in constant, unbearable pain, and the only thing that brings you relief is banned. This is the daily reality that Ms. Marlier is facing. She sought relief in cannabis after no alternatives were provided to her, but instead, she was imprisoned and deprived of everything she had. The applicant now brings three arguments to contend that the interference and omissions for both Article 8 and Article 1, Protocol 1 to the Convention are not justified. This will be illustrated with these three main points, starting with the harms of cannabis that the respondents mentioned. Secondly, making reference to Section 12 of the Law of Controlled Substances. And lastly, regarding the excessive burden imposed on Ms. Marlier under Article 1, Protocol 1. Your Honor, regarding the first point, the respondent pointed out that cannabis has negative effects, and they make reference to the UN Convention and how the Convention highlights these harms. It is precisely in the UN Single Convention on Narcotic Drugs of 1961 that recognizes the benefits of cannabis and how cannabis may be indispensable to relieve pain and suffering. Additionally, the respondents rejected that cannabis had helped Ms. Marlier had any benefits. Ms. Marlier instead, during the domestic proceedings, had testified of an amelioration of her symptoms. Given the gravity of her circumstances, should be taken into account, because even if a little, everything that makes her feel less pain and gives her relief should be taken into account. This is inconsistent with Semlin's zero-tolerance approach to cannabis, and more importantly, with Article 30 of its Constitution, which guarantees the right to the enjoyment of the highest attainable standard of physical and mental health. It also contradicts Semlin's approach to other drugs, such as tobacco and alcohol, as the EU Monitoring Center for Drugs and Drug Addiction has highlighted how the effects of tobacco may be comparable to those of cannabis. The applicant acknowledges these harms of cannabis, and it is precisely because these harms exist why the applicant claims that the appropriate legal framework must be in place in order to ensure the safety of its patients and avoid self-help and self-medication. Now, the applicant would like to move on to the second point under the rebuttal, that of Section 12. The respondents themselves have pointed out that Section 12 is just an exception. This directly means that by not constituting a remedy, it is not subject to the fourth-month time rule. Just adding to this, the lack of appeal renders this exception ineffective and therefore further supports the applicant's claims. Moreover, the claim of the applicant under positive obligations is grounded on the margin of appreciation. The respondents are shielding themselves from any blame by arguing that there is no wide margin of appreciation. However, when the State of Sunderland ratified the European Convention on Human Rights, it acknowledged and accepted that their sovereignty may be restricted in favor of the protection of human rights, thus accepting that in some cases the state will have to assume a narrow margin of appreciation. In this case, the court has previously ruled that where a particularly important facet of an individual's existence is at stake, the margin of appreciation should be restricted. This, Your Honours, in addition to the fact that the margin of appreciation should also be narrowed because there is a clear and general trend among Council of Europe states which accept the medical uses of cannabis. In particular, in MC versus Bulgaria, the court stated regarding consensus that the limits of the national authorities' margin of appreciation are nonetheless circumscribed by the Convention's provisions, interpreting them since the Convention is first and foremost a system for the protection of human rights. The courts must have regard to the changing conditions within the contracting states and respond, for example, to any evolving convergence as to the standards to be achieved. Lastly, Your Honours, the applicant would like to refer to the excessive burden imposed on Ms. Marlier because of the forfeiture which falls under the Article 1, Protocol 1 to this convention. The respondents pointed out that the applicant did not suffer a disadvantage or an economic disadvantage. However, how is Ms. Marlier not suffering a significant economic disadvantage? And more importantly, how is Ms. Marlier not suffering a disproportionate burden due to this forfeiture? She had been deprived of everything she had in addition to being imprisoned for 2.5 years. She is being treated like a regular drug trafficker, like any large-scale drug empire that was built on making people addicted to drugs. However, Ms. Marlier is not operating under those conditions. She is a sick patient that suffers multiple sclerosis and has no remedy to her illness. She resorted to cannabis in order to alleviate her symptoms and live a dignified life. It is important, the applicant would like to highlight that it is important to analyze the forfeiture of the 4 elements together, as the cumulative effect of all the forfeiture of the 4 elements, the land, the money, the dried cannabis, and the 6 cannabis plants is what makes the forfeiture disproportionate. In conclusion, the applicant submits that the State of Sunderland has violated Ms. Marlier's rights under Article 1, Protocol 1 to the Convention. Therefore, the applicant respectfully requests this court to declare the application admissible under Article 34 and 35 of the Convention, and adjudge that the respondent has violated the rights of Ms. Marlier under Article 8 and Article 1, Protocol 1 to the Convention, and also award just satisfaction under Article 41. Thank you very much.
Thank you, Counsel. Now the respondent state has the floor, please.
Of the court. First, we would like to emphasize that the applicant hasn't tackled any of our remarks regarding admissibility. Therefore, we again emphasize that we believe that the application under Article 8 is inadmissible. The applicant only stated that the trafficking of cannabis actually constituted important facet of private life of the applicant. Now, we do not dispute that if the applicant actually conducted herself as Mr. Thorne did, that it may constitute important facet of private life. However, again, that is absolutely hypothetical situation. The applicant was actually, and was proven beyond reasonable doubt, that the applicant has given cannabis to other people. Therefore, we believe that, again, her conduct falls outside of the scope of Article 8 of the Convention. Now, it was again stated that actually the State of Zeman did not take into account the applicant's health condition. However, it is not true, because as is clear from the reasoning of the Supreme Court, it is explicitly stated that the Supreme Court did take account of the applicant's health situation, and the account of the health situation of the applicant was as well taken by the ministry, which provided a succinct reasoning. Now, now we believe that, again, and we stress, and we believe that actually applicant has accepted that the states do enjoy wide margin of appreciation when it comes to regulating ethically sensitive issues and when it comes to regulating healthcare policy. And now the applicant has claimed that there is emerging consensus when it comes to use of compassionate use frameworks and when it comes to the use of cannabis medication. However, the applicant has provided no evidence why this court should change its stance from Torn v. Sweden, which is only 3 years, which was decided only 3 years ago, and the court stated in that decision that there is no consensus. Therefore, we believe that since the applicant has provided no evidence to prove otherwise, that the states indeed do still enjoy wide margin of appreciation. Now, the applicant only claimed that the state somehow narrowed its margin of appreciation by actually accepting and by being a party to the European Convention. However, this court has repeatedly held that under Article 8 of the Convention, especially when it comes to the healthcare policy, the state has a wide margin of appreciation. Now, when it comes to the Article 1, it was claimed that we somehow do not acknowledge that the confiscation order of 20,000 euro leave the applicant in economically vulnerable situation. We acknowledge that it can result in economically vulnerable situation, although it has to be stressed that when it comes to the home of the applicant, it hasn't been confiscated. But again, it is important to state that there is a principle that crime does not pay. And if actually the states would allow people to benefit from commission of crime by letting them to have a proceeds of the crime, there will be strong incentive for people to commit crime and acquire proceeds of the crime. And we believe, as we said, that the main aim of the confiscation order of 20,000 euros was actually to confiscate proceeds of the crime. That it was proven that it highly likely constituted proceeds of the crime as per paragraph 13 of the facts of the case. And then we would again like to stress that the applicant did not even claim in front of the domestic courts licit origin of the money. We believe that excessive burden hasn't been imposed on the applicant as she had the possibility to adduce evidence to prove otherwise. Now, for this reason, Your Honors, we submit that the application of Mrs. Adel Malieh should be declared inadmissible under Article 8 due to non-compliance with formal time limit and for being ratione materie incompatible with Article 8. And further, if this honorable court decides to proceed to the merits, we submit that there was no violation of Article 8 when it comes to the positive and negative obligation of the state, and that the forfeiture order of Mrs. Malieh satisfied the requirement of Article 1 of Protocol number 1 to the Convention, as interpreted by this honorable court. Thank you, Your Honors.
Thank you, counsel. The bench will now leave the room to deliberate for around 20-25 minutes. We return for an informal feedback session whereby the judge will provide some brief comments to the competitors. This will be followed by the closing ceremony. On the one hand, thank you for your cooperation, and I declare the hearing closed.
Oui, Nico? Ok. Tu regardes si ça rentre bien dans les hyperdeck, s'il te plaît. Bonjour à tous. Ceci est un test audio, c'est avec beaucoup de plaisir. Oh. Ok, test positif.
La Cour.
Sit down, please. So finally, we arrive at the crucial point. We will give a very brief feedback. It will be up to me to do it on behalf of my estimated colleagues as well. And then there will be the closing ceremony. The first things that I would like to highlight that it has been maybe our task, it is even harder than yours, because it was really difficult to tell among the teams who will win. Having said that, we share a common opinion on 2 points. The first one is that the performance were really, both performances were really brilliant, and it gives us a lot of hopes about the future of human rights, that it is the real task of judges, applicants, respondent governments, of everybody. And second, that we clearly highlighted that during even this competition, maybe each and every single teams has succeeded in improving the skill from the beginning to now. And this is very important. About the identification of the legal issue, the knowledge of the convention as well as of the case law, regardless of some tricky question, and the quality of the legal analysis, we are very satisfied, because I think you did your best and you really reach a high threshold in managing these 3 factors. As normally I did, we think that even the style of the presentation improved a lot, and it is absolutely appropriate. In this respect, the only few remarks we can do, it is the one to, it is really our task, it is the one to remember that before you, not only judges are sitting, but even human beings. And this case that it has been, it was very interesting case and tricky at the same time, put into discussion human beings and human life. And so it is sometimes good to reserve part of the pleading even in this respect. For example, the applicant team stressed this fact, touching the point of pain and handicap as well. So it means vulnerable people very well, but more on the rebuttal than on the main pleading. At the same time, the respondent state, I think that has some factual remarks that could be very interesting, and trying to focus really easily on the necessity of for striking a fair balance in between the threat to public order on the one hand that could, because of the narcotic effects of cannabis, then on the other side, the arguable relief of individual pain as set out by the expertise. This is a fact, in a general way, arguable, but this is a fact. But nonetheless, we are very satisfied. It will be up to the closing ceremony to tell who will be the win. For our part, I speak under the control of the composition. It has been a hard task, because in any event, the score is really close, the one to the other. Thank you at this team. Thank you to all the teams that participate in this moot court. Thank you to ELSA by our side, and our best wishes for your future. We are waiting for the proclamation of the result. Thank you again.
Juges, Excellences, membres du jury et chers étudiants, membres de ELSA, bienvenue à la Cour, bienvenue au Conseil de l'Europe. C'est un grand plaisir vraiment de vous accueillir aujourd'hui pour notre cérémonie et je vais continuer en anglais. This is the 13th Helga Pedersen Moot Court competition, and it fills me with pride that you are all here and that we are together for this flagship project of the Directorate of Communications of the Council of Europe for many, many years. Indeed, the Moot Court competition has become a priority for us at the Council of Europe, and hopefully also a key reference for you now and in your future career, and I know for many other students, law students across Europe. I think the competition reflects our common values, our shared values, and of course also our unique geographical reach. And today, and this year, 59 teams from 28 countries submitted written pleadings. That's quite a large amount, and I know for the judges and for the jury, quite a lot of work to get through. And this week, law students from 14 countries have made it through to Strasbourg. And I would like to mention those countries because it's important to underline who is represented here today. Bulgaria, France, Czechia, Georgia, Germany, Greece, Ireland, Italy, the Netherlands, Portugal, Slovenia, Spain, Ukraine, and the United Kingdom. So we are grateful to the Council of Europe member states, to all of them, for their support over the years, and in particular this time to Malta, which currently holds the chairmanship of the Committee of Ministers, as well as to Luxembourg, which was the previous chairmanship, to Netherlands, Switzerland, and the United Kingdom, who are our partners in this important project. And of course, I would like to congratulate the ELSA International Board for making this complex and demanding event and for managing it, for making it a reality and managing it so professionally. I can see this today, and I've heard so much about the work that goes on behind the scenes. And when I speak of that, the behind-the-scenes work, I would like to congratulate and express my gratitude to Sophie Lobby and to Maria Dominguez from my team, from my directorate, for being behind the scenes, but for organizing this for such a long time and pulling it all together. This is a success story, and I thank them from the bottom of my heart for doing this again and again, and it's a success again and again. Now, on a serious note, in this time marked by war, by democratic erosion, and by growing instability, especially in Europe, but not only in Europe, the rule of law, democracy, and human rights need to be protected more than ever. And I know you are convinced that this is our dedication, this is our aim. And so as we celebrate the 75th anniversary of the European Convention on Human Rights, our continuing cooperation with you, with ELSA, over the years is a huge achievement and remains very precious to us, and I know to all representatives here from the Council of Europe and the Court. Indeed, your work, your presence here, and all the pleadings that you have demonstrated and you have undertaken this week are a source of optimism and hope for Europe's future. So, thank you all for your dedication, and thank you for keeping the flame alive. And I now hand over to the representative of Malta, Fleur Abela, the Deputy Head of Mission from Malta, holding the Committee of Ministers presidency at this moment. Thank you very much for your attention, and have a great day and a great evening.
Excellencies, Director Holdgen, esteemed members of the jury, participants and colleagues, distinguished guests. It is a distinct honor to address you today at the conclusion of the Helga Pedersen Moot Court competition. While it brings back fond memories from my time as a law student back in Malta, this event is an event that exemplifies the fusion of legal excellence, youth engagement, and the enduring values of the Council of Europe. Since its inception, this competition has stood as a beacon of academic achievement and a dynamic forum where emerging legal minds engage deeply with the European Convention on Human Rights. It honors Helga Pedersen's pioneering legacy and serves as a powerful platform for the next generation to confront the evolving challenges of human rights across Europe. The participating teams have embarked on a demanding journey, arguing complex, fictitious cases before a simulated European Court of Human Rights. This exercise is far more than an academic test. It is a profound engagement with the principles of justice, advocacy, and respect for human dignity. The prestige of this competition is heightened by its setting in the very chambers of the European Court of Human Rights, reminding us all that the law is a living force with real impact on lives and societies. For Malta, this competition holds special significance. It reflects the core priorities of our presidency of the Committee of Ministers over the next 6 months, especially our commitment to youth empowerment, democratic resilience, and the safeguarding of the convention system. As lawyers and those who understand the vital role of legal frameworks in our society, we know that nurturing the next generation's grasp of human rights, law is essential not only for the development, your development, but also for the future defense of democracy and justice. In the words of Eleanor Roosevelt, a champion of human rights herself, where, after all, do universal rights begin? In small places, close to home, so close and so small that they cannot be seen on any maps in the world, yourselves. It is in the spirit that you, the young legal minds before us, are called to stand guard, defending rights, upholding the rule of law, and ensuring that justice is both accessible and effective. Today's democracy faces unprecedented challenges, from disinformation and misinformation to attacks on democratic institutions, to attacks on European soil. But the law and those who practice it with integrity, courage, and insight remain the most resilient tool towards the challenges communities face today. Competitions such as this sharpen your legal acumen, strengthen your principles, and prepare you to take up the mantle as guardians of justice. On behalf of the Maltese Presidency and in advance of the announcement, I warmly congratulate the winning team and all of you, the participants, for your dedication and passion. You are the future defenders of human rights and democracy, and I trust that this experience will inspire and guide you in your vital work ahead. As a lawyer myself, I urge you to remain hungry to defend and uphold justice, equality, human rights, and rule of law. I thank you.
Dear Excellencies and representatives of the Court, dear judges of the Grand Final, dear ambassadors and representatives of the permanent representations, dear representatives of Council of Europe, dear participants, dear organizing committee, and dear audience. My name is Natalie, and I am the president of the International Board of ELSA. It is an honor to stand here today as a representative of ELSA, and I would like to start by extending a huge congratulations to the finalist teams and everyone else who have participated in the 13th edition of the Helga Pedersen Moot Court competition. As Alena mentioned during the opening this Monday, the Helga Pedersen Moot Court competition has, since it was established 2012, become one of ELSA's biggest and most impactful projects. All the work of ELSA is guided by a set principle and values that unite more than 60,000 law students around 41 member countries. Together we work on contributing to legal education, fostering mutual understanding, providing opportunities for law students and young lawyers to learn about other cultures while being internationally minded and professionally skilled, and to encourage law students and young lawyers to act for the good of society. The Helga Pedersen Moot Court competition brings all of these values together, with a focus on human rights. It contributes to the legal education by equipping law students with the necessary and professional skills to be able to advocate for democracy, human rights, and the rule of law. But this competition is much more than an opportunity to enhance your skills. It's also an opportunity to meet like-minded country representatives, lawyers, and judges. And I would even dare to say, but most importantly, like-minded students. Throughout the regional rounds, and this week here in Strasbourg, you've had the opportunity to create a network by meeting students from all over Europe that share the same passion for human rights. Even if you have pleaded against each other in this competition, you might one day find each other as colleagues, working together on upholding these most important values. I can only imagine how intense the last couple of months have been, but keep in mind that you have grown tremendously, both personally and professionally. I am sure that the skills you have learned and the contacts you have made will be extremely valuable in your future. Aliena will soon extend her gratitude to everyone who has made this edition of the competition possible. But there is some support that extends beyond the competition, and I would like to take this opportunity to highlight this. As ELSA's main human rights partner, the Council of Europe supports multiple of our human rights initiatives. It is thanks to the Council of Europe these human rights projects, such as this competition, the annual Human Rights Campaign, and providing students with the opportunity to participate in the World Forum for Democracy through ELSA delegations, that the work of ELSA can have the reach as it has. It has been a pleasure working with the Council of Europe this year, and for this I want to thank Ms. Sophie Lobbe and Ms. Maria Dominguez. I know I speak not only on behalf of my board, but many generations of international boards before us, when I say that your continued support throughout not only this term, but all the years before, is a key component to ELSA's work with human rights. Last, but definitely not least, I would like to ask Aliena Trefny to join me on stage, Vice President in charge of competitions of the International Board of ELSA and the head of organizing committee of the Helga Pedersen Moot Court competition. Congratulations to you and your team, Aliena, for such a successful event. This edition of the Helga Pedersen Moot Court competition would not have been possible without you. Your commitment and passion to its purpose, judges, partners, and participants is an inspiration for us all. It has been an honor to be part of this journey with you. So with my last word, I want to invite all of you to join me in a warm round of applause to thank you and congratulate you and your team.
Well, this was a bit unexpected, so sorry for the improvisation. So good afternoon, also from my side, dear Excellencies, representatives of the court, dear judges of the grand final, dear ambassadors and representatives of permanent representations, dear representatives of the Council of Europe, dear participants, dear organizing committee, dear guests, and dear audience. It is a great honor to address you one last time before we officially close the 13th edition of the Helga Pedersen Moot Court competition and proceed to the closing reception of the event. Precisely 3 months ago, we concluded the regional rounds where all of the teams demonstrated that they deserve a spot in this final hour round today. And during this week, you have proven yourselves and your advocacy skills all over again. I am amazed and inspired by your dedication and hard work over the last 8-9 months since the launch of the competition back in September. And I hope that all of you present here will take this experience gained in the competition and carry it further to promote and help protect human rights. Helga Pedersen was a torchbearer of human rights in her time. You, the finalists, who have proved your qualifications and passion in the regional rounds held across Europe, and this week during the final hour round, to witness embody the same spirit. As an organizer, it is incredibly rewarding to witness this passion that you put into the competition, and it is a constant reminder of why I love personally the work that I do in ELSA. I hope that all of you enjoyed this experience and of course also had fun during the process, and I want to congratulate you on all of your achievements. I also want to thank all of the coaches of the teams, present or absent, for having supported the students over the past months through long nights and early mornings, reassuring your teams and giving them the confidence to excel today, which they did. As this is a closing address, I would like to thank everyone involved in the planning and execution of the 13th edition of the Helga Pedersen Moot competition. First, to Ms. Susanna Kovalova and Ms. Slavica Čuplic for their unwavering support of the competition by providing us with a new case every year. So if I may ask you to the stage. Then I would also like to thank the honorable judges of our event. Thank you for believing in the project and your willingness to contribute to its development. We were honored to even have 3 acting judges from the European Court of Human Rights from San Marino, Albania and Sweden, 2 previous judges from the court from Ukraine and Armenia, as well as a representative of the registry of the court, as well as one of our case authors here with us in the grand final. Thank you for your support, and as a symbolic gesture, we would also like to give you some gratitude diplomas, so if you could please join me on the stage. I would also like to take a moment to thank the permanent representations of Malta, the United Kingdom, Luxembourg, the Netherlands, and Switzerland for their support for hosting the opening and the closing ceremonies. Your long-term support proves invaluable and allows us to organize each edition at a higher and better level. So thank you also very, very much, and I am particularly excited for the closing ceremony hosted by Malta. Thank you. Then I want to convey my deepest gratitude to the Council of Europe and the European Court of Human Rights for their support provided to us in the past months. I specifically want to thank Ms. Martina Darvaux for the collaboration and especially in arranging the first ever live stream of this grand final, which is a very big deal for us as well. And I hope that many of your close friends and families have tuned in and followed us from back home. So thank you, Martina, for all the collaboration. If you could also come to the stage. And then, of course, since the Helga Pedersen Moot competition is jointly organized with the Council of Europe, I also want to thank specifically Ms. Sophie Lobé and Maria Dominguez for their institutional and organizational support on behalf of the Council of Europe over these couple of months. It has been a true pleasure working with you, and your availability and overall support of the organization, ELSA, and the competition specifically means a lot to us. So if I could also ask you to join me on the stage. Finally, I would like to thank the people who are not only excellent organizers, but have also grown near and dear to my heart throughout the year. The ELSA International team responsible for the competition, my director Theodora, my assistant for teams Jacek, my assistant for judges Elena, and my assistant for regional rounds, who is also my successor and will be the head of organizing committee of the 14th edition of the competition, Ines. My gratitude is immense. I would not have been able to do this without you guys, so very, very big applause. We will take an organizing picture, committee picture later. Promise, it's not going to be 15 people trying to take a picture now, but to my team specifically, thank you very, very much. I am also extremely grateful to the International Board of ELSA, Natalie, Mie, Paula, Nicola, and Nico, who have supported me throughout the whole year. And of course also the rest of the members from the International Organizing Committee who have worked tirelessly this week to make sure that everything runs smoothly. Without your dedication and readiness, this event would have not been possible. So thank you very, very much for your support. Today, the 23rd of May, marks the official end of the final all-round of the 13th edition of this competition, a project, the preparations for which started back in July 2024. It is my honor to have been the head of organizing committee and to have lived this journey with all of you. So thank you very much to everyone who was involved. And now we will proceed to the announcement of the award winners. So the moment all of you have been waiting for, I am sure. And I will be calling representatives from the permanent representations as well as from the court to the floor to hand out the awards. So for the first award, I would like to call Ms. Fay Carris, Deputy to the Permanent Representation of the Netherlands, to the stage to hand over the award for the Best Applicant's Written Submission. So, the award for the Best Applicant's Written Submission goes to team number 36, University of Ljubljana. Okay. I would now like to call Mr. Urs, Deputy Permanent Representative representing Switzerland, to the stage to hand over the award for the Best Respondents written submission. Okay, so this second award, written submission on behalf of the respondent, goes to team number 34, Universidad Complutense de Madrid. So now we come to the individual awards, starting with the award for the best orator from the preliminary rounds. And for this award, I would like to ask Mr. Sandy Moss, permanent representative of the United Kingdom, to the stage to hand out this award. So this first individual award from the preliminary rounds goes to Matej Pleva. Sorry. Then for the next two awards, so the best orators from the quarterfinals and the semifinals, I would like to ask Ms. Fleur Abalare, Deputy Permanent Representative of Malta to the Council of Europe, to the stage. So for the award for the best orator of the quarterfinal, we have Munira Hussein. Okay, and then for the award for the best orator from the semifinalists, from the semifinals, this award goes to Wada Minas. Thank you very much. So now we're nearing the end, 3 awards left. And the winner of the next award will win an internship at the liaison office of the Council of Europe in Brussels, the best orator of the grand final. And I now have the pleasure of asking Ms. Marlene Nazierli, Registrar of the European Court of Human Rights, to the stage to say a few words. And Mr. Judge Mattias Guyomar, also already on the stage, perfect. So I will give the floor to you.
Yes, thank you very much. So I would like to say a few words. I believe that moot courts are not simply an exercise or a game. They are a training ground for the advocates of the future. And today, one person has distinguished himself or herself with his persuasive skills, with his capacity and courage to present his or her case in front of you. This is all that makes a great legal mind. And the award that we're going to give, you have announced it already, it's 1 month internship in our Brussels office, is not only a recognition of your talent, but also a glimpse on what I hope will be a very bright future. So congratulations, and I would like the envelope, like in the Oscars, who has won. So the Best Orator Diploma goes to Matei Pliua. Congratulations. I'm sorry.
The only words I will say in French is bonjour et bienvenue à la Cour. As President-elect of the European Court, it's a great pleasure to have that occasion to meet you and just to say a few words. In today's troubled times, it's inspiring to host young law students who are motivated to uphold the values of the European Convention on Human Rights, the beating heart of our civilization. You are all winners by participating and by being here in the hearing room of the European Court. Today, you have pleaded before our judges, and I want to warmly thank the members of the bench. Your participation inspires and motivates us. You give us confidence for tomorrow. And I just say that you are the future of Europe. You are the future of the world. Human rights are universal. They have to be, how to say that, not only upheld, but embodied. And they are in your hands. And I would like, personally, in my future capacity, to warmly thank you. I'm so grateful. Congrats to all of you. As you know, as regards the award in this moot court, the winner takes all. But I won't sing. But I would like just to say that unfortunately, I have not enough time to sit in the bench and to hear the pleadings, but I'm sure that the winner and the runner-up have engaged themselves so strongly that you can be proud of you. And no more teasing. The winner is the team 63. I invite both. Voilà. And the runner-up, I invite also team 43. Mariana, what is the,
This
yes.
is for the winner.
Yeah, this is for the winner. And this is an internship at the court. You will have this great experience within the building with the members of the registry and the judges. And just a few, yeah, come on. Yes, I want just also to congratulate you. That's absolutely my view of a moot court. Of course, there's a prize for the winner, but we are grateful to all of you. So this is for you, and many thanks for having engaged yourself.
Thank you.
On va prendre des photos. Alors voilà, il y a aussi So just a picture with Mariana and myself. Okay. Bon, bah c'était bien qu'on dise un petit mot comme ça.
So this is your thing 23, right? Yes. Your 6x6.
Thank you.
So I think everything has been said. Congratulations to everyone here, in particular our winning team, of course, but of course also to our runner-ups, to everyone here. You have spent a lot of time in this competition. I have spent a lot of time together with the organizing committee organizing this competition, and it was an incredible journey. I will not forget it, and I want to thank everyone who was part of this journey. Now, before we go to the closing reception, we have participation certificates for all of the teams. I invite everyone who wants to already go ahead. Nobody is obliged to stay here, but for the sake of the participants, I encourage the teams to stay in the room until we have handed out all the participation certificates until the end, because as I said, we have been through this journey all together. Okay, I will be calling out the teams by number, and you can come to the front and we can take a picture. Okay, so first I am calling team 9 to the stage to collect their participation certificates. Okay. Next we have team number 10. Then next we have team number 12. Then the next team is team number 18. Followed by team 19. Next, I'm calling team 26 to the stage. The next team is team 30. Next team is team 31. Then next we have team number 32. Next up, we have team number 34. Next up, we have team number 36.
Voting rights, and I'm sitting present voting and play this and this one.
I forgot. Next up, we have team number 41. Who is not here currently. Then we have team number 42. Next up, we have our runner-up for the team 43. Next up, we have team number 53. Okay, then we have team number 55. Next up, we have team number 62. And last, but as we saw today, definitely not least, team number 63. Okay, now we are officially done. I have the pleasure of closing this 13th edition of the Helga Pedersen Moot competition, and yeah, enjoy the closing reception. Thank you everyone very, very much.